Hi. Today I'm going to try to cover the remaining substantive areas that get handled in divorce cases. Again, it does not mean that the things I talk about today necessarily have to get covered in your divorce case. There are divorce decrees that end up being entered without any of this. There are petitions that are filed that don't ask for these things. But these are substantive areas that can be decided in a divorce case, and you need to be aware of them if you're going through a divorce, whether it's because you want to or you don't want to. The main thing I want to spend today's video talking about are the claims that you can make against your spouse within the context of the divorce. We've already talked about the status of the marriage property division, the children's aspects, the custody part of that, the child support part of that. We've talked about spousal maintenance. And now we come to the part where we're talking about suing your spouse as a part of the divorce. Early on, we talked about the fact that any divorce is a lawsuit. But what I'm talking about today is making an additional claim in your case that feels different than just the divorce. So what am I talking about? Something that can come up, unfortunately, quite often is that when somebody is a victim of family violence, almost by definition, they have also been the victim of torts known as assault and battery. An assault in torts is being put in fear of being touched. A battery is actually being touched. Those can be claims that can be brought against your spouse if your spouse has committed those things, has done those things to you. You can file a tort case, an assault case against them. I'm not talking about the criminal aspects. I'm not talking about what can happen within the criminal justice system. And we haven't touched on at all the idea of protective orders. That's not what I'm talking about. I'm simply talking about as a part of a petition, either at the outset of the case or in an amended petition filed while the case is pending, one party pleading against the other, that party has committed assault and battery in a civil sense. The next thing that comes up is intentional infliction of mental anguish. It's also known as intentional infliction of emotional distress. And it's one of my favorite torts because it tells you what it is right in the name of the tort. What you're talking about is somebody intentionally causing the other person mental anguish, intentionally causing them emotional distress. Is it possible that this type of claim can be used in lieu of those that we no longer have in Texas, like alienation of affections? If your spouse is having an affair, is it possible that you can file a claim against them in the divorce for intentional infliction of mental anguish or intentional infliction of emotional distress? My position on that is it's possible. Some judges would agree with me, some judges may not agree with me. But I do believe that under Texas law, it's possible to file that claim and seek damages separate from the property division, seek actual damages against your spouse in that situation. Now, you've got to be able to meet the criteria. You have to actually have legally cognizable mental anguish and emotional distress. That's more than just being upset about it. We're not going to cover in this video all the details in case law on what the definitions of that actually are. I do want to touch on is this. Some people hear the name of the tort, intentional infliction, and what they hear by that is what's in the name, intentional. So they think, well, as long as I can keep the other person from proving that what I did was actually intentional, that that's what I meant to do, was cause the mental anguish. Well, that's not what the case law says. In Texas, intentional infliction includes recklessness. So it includes the idea of, I don't care if that happens to them. I'm going to do what I want to do, and I couldn't care less if this causes them mental anguish or emotional distress. That can qualify under an intentional infliction claim. You can have a claim for defamation, which would be slander or libel, but you can just refer to them collectively as defamation. If your spouse is maligning you, if they are saying false things about you to family, friends, others, posting things that are false about you, that may give rise to a defamation claim. If your spouse has given you an STD because they've been having an affair, that may give rise to a separate claim for damages that you can bring. If your spouse has posted what they call revenge porn, if your spouse and you have some intimate photos of each other and your spouse has threatened or has posted images of you that you would not want out there, it's possible they could give rise to a claim. Conversion is another tort in Texas. It's what you think of in the criminal sense as theft, but we call it conversion in the civil context. And that's taking something that's yours and maybe giving it away. Maybe you had some separate property, so it's not part of the community estate. And during the divorce or just prior, maybe once you've moved out of the house, your spouse takes things that they know are your separate property and they sell them at a garage sale. They give them away. They destroy them. All of that could give rise to a conversion claim. Another claim that is possible that I think is actually underused in divorce cases is invasion of privacy. There are actually in Texas about 5 different types of invasion of privacy torts that can be brought. One of them that is most common in a divorce context would be tapping the other person's phone, or in just the sense of planting listening devices. In this day and age, it's never been easier to put a Ring camera somewhere and record something that the other person is doing. When you record them having a telephone call with somebody that you're not a part of, if you're not part of that conversation and you record that conversation, you may give rise to a claim against you of invasion of privacy. There are other ways to have an invasion of privacy also. I will say that some of it can be somewhat similar to defamation, such that you are making someone look bad to others, and there may be a distinction there, whereas defamation has to be false. It's possible that with invasion of privacy, it may be something truthful, but intended to make the person look bad to others. It's possible that that could be a claim. There are business torts that can be brought in a divorce context. If you are the owner of a business, particularly if your business is separate property, you started it, say, prior to the marriage, and so it is separate property. Now that can get a little confusing, but let's say you incorporated it or you had an LLC prior to being married. If the business is separate property, it probably raises the likelihood of these business torts even more. But I'm not going to rule out the fact that they may be available when you don't have a separate business, or even if you're just an employee of another business. There are business torts for intentional interference with contractual relations. There are torts for tortious interference, intentional interference with prospective business relations. If deals are in the works but haven't been completed yet, it's possible that there could be a claim if your spouse has caused that deal to go south based on their conduct of intentionally trying to damage you and damage your ability to carry on your business. There's even business disparagement, meaning it's like a defamation claim, but for a business. So I'm not saying something false about you. I'm just telling people false things about your business. Business disparagement may be a separate tort claim that can be brought. And then interestingly, there are some statutory add-ons. So all the things I've talked about so far are what we call common law torts. But there can be some statutory things. One of those is something called the Texas Theft Liabilities Act. And it's possible that under a certain fact pattern, that could come up in a divorce case. And that really gives more leverage if it's a conversion case, particularly if the dollar amount is very low. Maybe your spouse has destroyed something of yours that is a keepsake, and so monetarily there's not a lot of value to claim, but under that Texas Theft Liability Act, it's possible to bring a claim that would allow you to force the court to give you attorney's fees should you prevail. There is a statute that deals with intentional interference with child custody. So it's possible then, and we haven't talked about this, but it's possible then to actually bring other people into your case and file a claim against third parties. Maybe your spouse's parents have interfered with court orders that allow you to have possession of your children, and now they've intentionally hidden the children from you. That could give rise to a claim. So that is not an exhaustive list by any means. There's some thought out there dealing with fraud in marriages, and you'll hear some lawyers even say, oh, you can't plead fraud in a divorce case. you can only plead what's called fraud on the community. And that's what we talked about in that other video where we talked about waste. That would be fraud on the community. But I can tell you there can also be actual fraud where one person commits fraud as a tort against the other person. It's probably pretty rare in a divorce, but under certain fact patterns, it could arise. In this video, I'm not trying to give you a complete exhaustive list of all of the claims that could be made against your spouse. I'm simply trying to give you some examples and let you know about some of the claims that can be made. But the biggest point I want to make is that claims can be made, because here's the kicker of all this. If you don't make the claim during your divorce, then you may be barred, meaning stopped, prevented from ever making the claim. In other words, you can't have one of these claims, theoretically. You can't have this fact pattern. These things cannot have happened to you, and then during the divorce, you just choose not to bring them. But then later, maybe a year later, when you get upset about anything, maybe something over the kids, or maybe you start thinking back on how the divorce went and you don't like how it went, and you remember back and say, oh yeah, but during our marriage, this or this happened, and I remember that video that told me that I could bring a claim, so I want to bring it now. There's a good chance that if you did not bring that claim during the divorce, you're never going to be allowed to bring the claim. So you need to talk to your attorney about all of these possibilities and talk through your fact pattern. That's one of the reasons why we tell people that they need to give us a timeline of their lives. They need to teach us. If I'm your attorney, you need to teach me about your life. You have lived your life. I have not lived it. The only way I know what has happened to you is by you sharing things with me. One of the best things to do is to create a timeline, and in that, hopefully you will indicate some of these things. I'll see some of this, and then I'll be able to do what we learn in law school is called issue spotting. I'm looking for issues to talk to you about, things that may need to be pled in the case. Really, the only two other things that I want to talk to you about, again, this is not meant to be exhaustive. There are probably things that I haven't mentioned that can end up in decrees. We haven't talked much about filing a claim against other people. There can be other complications in a divorce. You can actually have a situation where one of the people going through the divorce, or both of them, owe money to somebody, and that person files into the case as a creditor seeking relief, saying, hey, while they're dividing up the property, divide some of it up my way because they owe me money. So that's a possibility, but that's not real common. But a couple things that you do see very often in a divorce case are something dealing with taxes. So if you're going to settle your case, you're going to want to at least think about, should you put a section in there dealing with taxes? There's no law that says you have to have that section in there. Or if you go to trial, it's possible, in fact, I would say likely, that the court will put some provision in your decree about taxes. And I'm not going to try to give you tax advice. I don't give tax advice. If you look at my fee agreement with clients, it will tell you 3 different times that I don't give tax advice, but the advice I'll give you is to be aware that taxes can be a big issue as you've gone through a divorce and for years after that. And so I strongly recommend that you talk to a tax attorney or to your CPA about those tax issues and make sure that if you do need some specific provisions in your decree, you get them in there. And then the last thing is this, and that is the paperwork that has to get done after the divorce is done. Some of this you can't really do before the divorce is done. So then the issue comes up, how are we going to cause this to all happen after the divorce is done? And that's through a part of the decree that can order people to execute documents. So you want to watch for that in a final decree. That's pretty much all of the different sections of a Texas divorce. And in the next video, we're going to look towards pulling it all together and talking about what your options are if you're facing a divorce, whether it's because you want to or even if you don't want to.